It was due to the court's calendar. Originally, I had been scheduled to be in a 5-week trial starting February 13th. And then that was delayed by 2 weeks, and ultimately that trial was adjourned. And so that was the reason for the hearing being scheduled on today's date. So for now, I don't anticipate your client having to talk. I can just hear background. So I'm just going to mute it. And if we need to talk to him, we'll unmute. There'll be a 30-second delay unless he has the device there, but to unmute. But in any event, I think I've accurately stated kind of the timing of the requests. As I understand, the additional paperwork that was filed as recently as April 12th, and I trust you've seen that, Attorney Covey?
Judge, yes, I did see, I think you're talking about document 566.
Yes.
I have that right in my hand.
All right. And so does the state have a grand total for additional restitution the state is seeking?
So to be clear, Your Honor, on the document, is that one that's titled, well, the first thing is crime victim compensation? Okay, thank you.
Yes, I just couldn't tell if that, I didn't do the math, if that's.
Yes, I wanted to be clear on that. So at the bottom it notes you've already ordered sum of 124,220.65 to crime victim compensation.
Yes.
The grand total that's listed at the top of 134,466.85 encompasses that 124. So this is not in addition to. Okay. So our request for crime victim compensation is 134,466.85. For Wilbur and Associates or Hartford Insurance, total request is $108,164.61. Optum subrogation, $118, $805.62. Progressive Insurance, $10,000 for victim GGG, and Progressive Insurance, $104,662.64 for victim Q.
All right, and I believe your letter of November 29 indicates the additional amounts that you're seeking. And then this document really totals things up.
Yes, it does. And at the bottom, already ordered the EMC insurance for Waukesha School District. That was already ordered, and there's no update to that number. So that number can remain as fixed.
I'm just going to do a quick calculation to determine the additional amount to crime victim compensation the state is seeking. Looks like that's $10,246.20.
I'm sorry, can you repeat that number?
Assuming I hit the keys on my calculator
okay.
correctly, it's the difference between the 134 plus minus the 124, and that's $10,246.20.
Yes, we agree with that.
All right. And then the additional other amounts to other individuals, namely insurance companies, are really those 4 amounts that are listed in the near the bottom of this document to Hartford Insurance, the Optum, and Progressive for 2 different victims.
Yes, correct.
All right. Is that your understanding of what was being requested, Attorney Covey?
Judge, it clarifies things. I had thought that the state was asking for an additional, the full 134,466.85 in addition to the 124. So my original number, I thought was just north of 476,000, but it seems like it's closer to about 350,000, give or take. I'm using round numbers because I don't have a calculator with me.
Understood. It's my understanding from the document that you filed on behalf of Mr. Brooks that Mr. Brooks is not contesting the loss that was suffered, but rather his ability to pay.
Judge, that is correct. I'm not asking for, at least for anything to date, anybody to present extra documentation as to the accuracy of these numbers. It's just on his earning ability and lack of funds.
And was that the state's understanding as well?
Yes.
I know in the filing from Attorney Covey, I don't recall if it was the letter or the actual motion to deny. There's a claim that Mr. Brooks is indigent based upon his incarceration. Is the state going to take any issue with that?
We're agreeing to that fact, Your Honor. We've reached a stipulation with Attorney Covey that recognizes Mr. Brooks, to our knowledge, is indigent at this time and that his future earning capacity would be limited to prison wages.
And that's an agreeable stipulation to the defense?
Judge, we reached that agreement yesterday. Absolutely. I suggested it.
I don't want to be presumptuous, but I know the last time the court addressed restitution, the state was requesting really an order related to an escrow account. Should there be future payouts or earnings by Mr. Brooks, will you be making the same request?
Yes, and I noted that is in the original judgment of conviction that was filed by the court on November 17th of 2022. You had made that order and that finding at the time of sentencing, and you had also indicated restitution costs and surcharges and fees to be collected from prison monies pursuant to statutory authority. And so we're going to ask both of those orders remain in place.
Will your client have any objection to that?
If there's additional restitution, I don't object to the escrow account.
That would be for monies paid to Mr. Brooks, not a restitution, not an escrow account beyond that. Under 949-165.
I'm sorry, counsel, if I may, just for 1 second. Oh, yeah. Okay, thanks. Judge, counsel explained to me briefly what she was getting at. I don't have any objection to that.
All right. Then it seems to me there's really just some legal arguments as to whether I should order the additional restitution.
Yes, Judge.
The stipulation then would put us in a position where Mr. Brooks does not need to testify. That's my understanding, and that would be how I would proceed. Anyone see that any differently? Attorney Opper?
We do not.
Judge, that was the reason why I suggested the stipulation.
All right, thank you. Then, since it is the state's request for additional restitution, I'll hear from the state.
Thank you, Judge. Your Honor, we are asking this court to order restitution in the full amount as proposed in the document we filed yesterday. I think you said it was 566.
Yes.
Thank you. I'm sorry. I just don't know the document number.
Yes, it is document number 566.
Judge, we certainly understand ability to pay as one of the factors that the court is to consider here, but we'd like to highlight a couple of things. First of all, one of the goals of restitution is to rehabilitate the defendant. We think that is an important goal in this case, noting the damage that was inflicted by this defendant to multiple victims. We would note that most of the monies, or at least a majority of the monies, came from the Crime Victim Compensation Fund, which really is funded by taxpayers. It's a state fund, and that I'm glad to see on this list there's no individual victims that are still looking to be made whole, that it was either covered by Crime Victim Compensation or insurance companies. So I think it's important that we recognize that and the desire for the public to have those monies repaid to the CDC if appropriate. As far as the insurance companies, the same, Your Honor. While I understand they operate as a for-profit business, these were substantial expenses that they had to cover for their insured, for their clients, and a direct result of the defendant's conduct and the significant injuries that several of these victims suffered as a result of Mr. Brooks' behavior. So we do believe that it's both fair and appropriate for the court to order the whole amount, notwithstanding that limitation. The reality is that perhaps this will never be achieved by Mr. Brooks in his lifetime on prison wages, but it would serve a rehabilitative purpose, because should he ever receive employment within the prison system and a wage, albeit minimum, it would be a reminder to him and aid in his rehabilitation, that for whatever monies he earns in the prison, a portion of it does go back to the Crime Victim Compensation Fund. And the other thing is, Your Honor, of course, we don't know if an escrow account would ever be needed under 949.165, but I think we can make a reasonable observation here that there is potential for Mr. Brooks to obtain money in the form of payment to sell his story, to engage in a book deal or a movie offer or whatever it is. We know that this case garnered international attention. It's not beyond the realm of possibility that someone may at some point offer him some funds or some sum of money to share his perspective on this case. And so I would hate for this court to, set $100,000 today and then tomorrow he gets a $500,000 book deal. That would be offensive, I think, and go beyond the scope and the purpose of restitution. So for that reason, Your Honor, even noting his current limited ability to pay, we feel it's appropriate that you order the full amount as requested. Thank you.
Before I turn to the defense, I don't want to make any assumptions, but it's my recollection, probably during the sentencing, maybe even during some of the witnesses, or even during maybe discussion related to jury selection. Obviously, the community had set up a fund for victims to seek reimbursement. It's my understanding that this restitution amount that's being requested would be larger. I don't know if it would be substantially larger if all losses were being requested by the state.
That's an accurate statement, Your Honor, and I think it's very fair to say it would have been substantially larger if it not had been for the generosity of individuals who contributed to those funds.
As I recall, were there millions in that fund at one point?
I believe that's accurate. Yes, I've confirmed that.
All right. And then I'd also heard, but I don't know if there's any truth to this, but that at one point, Mr. Brooks himself may have demanded payment to talk to a news organization or some media outlet. Again, I don't want to make assumptions, but I had heard that at one point.
Attorney Wichow and I are, I've heard that as well, but I can't confirm that with any certainty, Your Honor.
All right, thank you. Then turning to you, Attorney Colby.
Thank you, Judge. Although I'm relatively new to the case, I can state just from my review of the file so far, I haven't heard anything at all about anybody offering any kind of book deal or any kind of sums of money in any way, shape, or form to Mr. Brooks. I think it's the odds of Hollywood knocking down his door to give him lots of money for his life story. I think given the totality of the circumstances of this case, I just think are so minuscule that I don't think that argument should be given much weight. I also couldn't imagine any of the media, whether it's a YouTube blogger or the people that are next door to this courtroom, offering Mr. Brooks any money for some kind of exclusive interview. I cannot foresee the future with 1,000% certainty, but I think the odds of that, again, are just exceptionally low. I appreciate the fact, Judge, that the state's stipulating that he's indigent. I think counsel mentioned minimum, and I just want to make sure that the court recognizes that we're not talking minimum wage as a legal $17, $18, $19 an hour for prison work. If he's offered work in any of the facilities that he's going to be serving time at, At best, he'll be getting perhaps a few dimes an hour for janitorial work or cleaning up the kitchen. The type of wages that are earned by inmates in our correctional system, they're not used to save up lots of money. They're used to sometimes save up to buy a bag of Doritos or some deodorant or toiletries. That's essentially his earning capacity. If they let him work, perhaps $1 or $2 a day if he works the entire day. So that's the reality of what he's facing. And Judge, counsel touched on this, and I appreciate her argument. Frankly, whether you order 50,000 or 500,000 or 5 million, it's very unlikely that Mr. Brooks would be able to pay even the smallest fraction of that. But this hearing still matters. This is not just a moot point or a moot exercise, because you do have the duty, Judge, to balance 5 sometimes competing factors as listed in Wisconsin Statute 973.2013. I mentioned it in my motion. And then, of course, the 5th factor was I sent a letter to the court about that yesterday. The 5 factors are the amount of loss suffered by any victim as a result of the crime considered at sentencing. 2, financial resources of the defendant. 3, the present and future earning ability of the defendant. 4, the needs and earning ability of the defendant's dependents. And 5, any other factor which the court deems appropriate. Judge, I'll go just a little bit out of order. On subsection 4 regarding Mr. Brooks' dependents, recognizing that he's currently serving multiple life sentences consecutive, realistically, he's not going to be able to support his dependents anyways. And so that factor isn't really on point for this hearing. On the first criteria, the amount of loss suffered from the victims, I'm not surprised that the totality could be in the millions of dollars. I'm sure it's an absolutely enormous amount. And you have that discretion to give that factor great weight. I concede that. But I also hope that you consider the next 2 factors as well, and they kind of go together. His earning ability and his current financial resources. I hope that gets great weight as well. She's had significant financial problems even before this case. I believe he qualified for a public defender from day one. If he were to testify, he would testify that he had no savings, no assets. He doesn't have any kind of inheritance coming down his way. Nobody owes him any kind of money. I don't think anybody would dispute those facts. If you add on another $500,000 or $350,000 to what he's already been ordered to pay, which is in excess of $171,000, then you are sending a message that the 2 factors, his poverty, his earnings abilities, just don't matter. And I hope that they should be considered. Finally, Judge, subsection number 5 is the catch-all section, where you can consider any other factors which the court deems appropriate. I'm not sure if the amount of restitution in document 566 is the sum total of what might be requested in future restitution hearings. The law, there is case law that states that a request could be made well past the 90 days after the sentencing hearing. We could object to it, but a lot of courts have upheld those. And I believe, just for the sake of judicial efficiency, since he cannot pay anyways, since he really couldn't raise more than a couple of dollars a month anyways, is it worth the court system's resources, our time, the court's time, the community's time, to have potential extra restitution hearings when the ability for him to pay anything is going to be minimal or nil? And Judge, finally, I guess one last thing. I would respectfully disagree that this is about rehabilitation. Given the length of Mr. Brooks' sentence, I think this is just more additional punishment, adding extra zeros to the judgment of conviction for money that he owes. I recognize the gravity of the harm, and I mean no disrespect to anybody who suffered any injuries or the medical bills from this case. But given the totality of the circumstances, his multiple life sentences, I just don't think it makes sense to add on any additional restitution. It's just more paperwork, potentially extra hearings for no really just purpose except to add extra numbers on the judgment of conviction. I'm happy to answer any questions you might have, Judge, and thank you.
All right, thank you. First of all, I do want to thank the parties again for the stipulation. I think that certainly has made this hearing one that is running quite smoothly, but also kept victims from having to testify again regarding the loss that they suffered, and even frankly, the representatives from crime victim compensation or the insurance companies related to this. I also appreciate the stipulation from the state regarding the indigency. I think that's a testament to both counsel here and their willingness to, look at this objectively and what the purpose of this hearing and what the court needs to do. It is true that the court does need to consider the statutory criteria in 973.20. That's been referenced by Attorney Covey, both orally here in court today and in his motion to deny restitution. There are 5 criteria, really, when you look at the statute: the amount of loss suffered by any victim as a result of a crime considered at sentencing, the financial resources of the defendant, the present and future earning ability of the defendant, the needs and earning ability of the defendant's dependents, and any other factors the court deems appropriate, really what we would call the catch-all. Obviously, this concerns a case where Mr. Brooks was convicted of dozens and dozens of crimes based upon conduct stemming from him driving an SUV through the Waukesha Christmas parade. There were 73 named victims, one of whom was the victim of the domestic abuse related convictions. And then, of course, the 6 individuals who perished as a result of his conduct and the 68 others who were injured. There are family members that are represented by each of those victims as well. This was and remains a very significant crime that has and will have lifelong effects for not just Mr. Brooks, not just these victims, but the community as a whole. And the losses that were suffered apart from the death and the injuries is only in part represented by the dollar figures that have been requested by the state on behalf of the victims. And that's what prompted one of the questions to Attorney Opper is that there was, and I think perhaps, I don't know if it still has any money left in it, but we know that there was a fund set up by community members, really funded, I'm sure, if you were to look carefully, probably internationally, with millions of dollars that helped defray costs and the loss to many of the victims. There was testimony, whether during the trial or probably more at the sentencing, of individuals who did not have insurance and suffered out-of-pocket losses. And thankfully, the community stepped up, crime victim compensation stepped up, but it would have been significantly more in terms of the dollar amounts that the state is seeking, but for that fund that had been created and used to help the victims of Mr. Brooks's crimes. And so I think that's an important consideration for this court to consider. In addition to the type of loss that was suffered here, I mentioned this earlier, there was death, great bodily harm, certainly emotional and physical trauma, and because this involved a parade and Mr. Brooks driving through it, there's also that sense of security and safety in our community that he robbed not just the parade goers on that fateful day, but really the community, the state. I think anyone who's heard anything about this case would feel a real sense of security that was stolen by Mr. Brooks. I do think the state's argument on rehabilitation is a solid argument. The bottom line is Mr. Brooks completely minimized his conduct both during the trial and at sentencing. And it is important, if only symbolic, that while he is in prison for the rest of his life, that whatever meager sums he might make with a prison wage, that there be a reminder to him why there is this deduction from his monies, that his ability to go to the canteen or to buy some extra item that's not otherwise provided by the prison, that there be that reminder to him that he doesn't have even the full access to whatever money is on his account. Now, I'd remind everyone the law caps what that deduction will be at 25%. I think that's a very clear recognition by our legislature of the balance that the system needs to have as it relates to prison monies. And I think that's an appropriate cap. I also think it's important that this court consider that the vast majority, I shouldn't say vast majority, but a significant amount of the restitution is to crime victim compensation, which is a state fund, largely, if not all, funded by taxpayers. And even if there were some grants that are there from federal resources, which I imagine there might be, that's still taxpayer funded. And so I think that's another consideration for this court to look at and consider. Now, I do have to balance. I'll look at all the criteria. Obviously, significant amount of loss. That's criteria reflected in sub 13 sub A. Sub 13 sub B, the financial resources of the defendant. Clearly, they are extremely limited at this time. However, there is absolutely no doubt in my mind that the possibility exists for Mr. Brooks at some point in the future to possibly profit from a book deal, a made-for-TV movie, a movie, whatever it may be. Maybe it's just doing an interview or whatever the case may be. I don't think that can be ruled out, even if he is obviously the person who was convicted of that. But there was international attention. This court had Court TV in to stream the trial. This court has always streamed every hearing as it relates to this case, in part because of the number of victims. And I could not, I don't have a courtroom big enough in this county to hold all parties involved. Certainly during the trial, this courtroom was packed on a daily basis. And to say that the trial went viral, I think would be an understatement. And so all of that relates to, though, that catch-all factor and the possibility that Mr. Brooks could come into a sum of money at a later point in time because of the story that he could provide or tell on his own behalf. You need only look at Netflix to know that crime stories are incredibly, they're things people want to watch. People find them interesting. People want to know the why. They want to know the how. And it's certainly not just this case, but we've seen it, and not that that's been on Netflix or anything, but other cases have captured the attention. So I don't think it's beyond the it's not an impossibility, let's say. It's, I think, a very real possibility that someone might produce something someday for more of a commercial or theatrical type purpose, even if it's a true crime type situation. And that it's possible that Mr. Brooks could profit from that. And that certainly is why at the time of sentencing, the court address the request by the state related to the escrow account. I think that's important to do that here. And so when I balance all of these things, when I consider the significant amount of the loss, the court's desire to hold Mr. Brooks accountable, and even if it's a small reminder with his prison monies, that does serve a very important rehabilitative role, because even though he's serving successive life sentences, we all hope that one day he truly is able to accept full responsibility for what he has done, not minimize his conduct, and so that this award of restitution in full, as the state has requested, is important. And I will grant the additional amounts as I indicated earlier. It's $10,246.20 to crime victim compensation. That total then to them for the judgment of conviction is $134,466.85. Then to Wilbur and Associates, which is Hartford Insurance, $108,164.61. Optum Subrogation, $118,805.62. And then Progressive Insurance for victim GGG, $10,000, and Progressive Insurance for victim Q, $104,662.64. That is, of course, on top of what a court had already ordered to EMC Insurance of $47,193.29. So again, I'll grant the request of the state. We'll also include that it be payable out of any prison monies per state statute, and the court under 949.165 makes the additional amounts of restitution ordered today subject to the escrow account under that statute. Anything the state thinks I've overlooked as it relates to this?
No, Your Honor, thank you.
Anything the defense thinks I've overlooked as it relates to this?
Judge, I think I'm good. I'll just let Mr. Brooks know that I'll set up a phone call with him soon. If you could just wave your hand so I know that you heard that, sir.
Oh, and
Yeah,
I
you did.
forgot to state this at the beginning of the hearing. Obviously, it made reference to the video conferencing. He's appearing through the Zoom platform through our technology. It's working. I can see him. You can see him. He's indicated twice now that he hears us. Clearly, the technology is working and it meets the minimum standards for video conferencing. And given that there was no testimony that was taken today, too, was obviously very appropriate for him to appear that way. He has 20 days from today's date to appeal the decision of the court. I will, of course, make sure an amended judgment of conviction is done as quickly as possible, get that signed, and that will be uploaded to the e-filing system. All right, thank you, everyone. That does conclude our hearing today. Good luck.
Thank you, Judge.
Thank you, Judge.
Mr. Brooks, I'll talk to you soon.